compliment you on your effort, Mr. Chairman, to get some legislation moving on this. I have attempted over many years to make changes in the public record law, in particular on the enforcement side of things, without success. I'm hoping your effort will be successful because obviously we need some changes. I'd like to speak in categories, that is to say, to some of the issues that are distinguishable in this area. For instance, the area of enforcement, which I think is the area where there's probably the greatest consensus of a need to make some changes. One of the great frustrations of mine in the area of enforcement has been that the ultimate remedy that I have, or my office has, to enforce the public records law is referral to the Attorney General or the District Attorney's Office. And that has not always proven to be an effective means of enforcement. Without getting into past history that serves no purpose, it simply has not been an effective way to make sure that once a decision has been made, once an order has been rendered by the supervisor of public records to make a record public or to give the requester the record they seek, if an agency is recalcitrant, if it refuses to cooperate, that remedy has not been effective in the past. I will tell you, and I'm pleased to say, that the new Attorney General and I, Attorney General Healy, have had very constructive discussions relating to referrals. And I think we do have a protocol going forward to refer matters in the current situation, which I think is helpful and certainly a remedy. I would suggest, going forward in terms of legislation, that any legislation find a more definite enforcement approach. A couple of thoughts. One would be for the Attorney General to designate a specific officer of theirs that would be the Office of Enforcement within the Attorney General's office, a specific Assistant Attorney General. The other would be the possibility of having the supervisor himself or herself, that is the employee of the Secretary of State's office, who is the statutory determinator of whether it is a public record, have the right to go and enforce the decision themselves. I have no particular prejudice. There are benefits of each, but I think that it is important that there be a more clear line of authority in the area of enforcement. Another area that your legislation speaks to in the same vein, which I strongly support, is the idea that when a requester finds themselves or is willing to go to court themselves, they ought to be able to recover court costs. There ought to be some means by which they would get back the cost that they would incur in seeking to enforce the order of the supervisor. Also, there might be some system of fines on agencies that fail to cooperate. These would be some clear areas of enforcement. I think that the idea of having a specific person in each agency designated as the public records officer makes a great deal of sense. One of the frustrations that the supervisors through the years have found has been the absence of authority, specific authority regarding where, in fact, the authority rests to make a decision on public records. So you'll go to an agency and you'll be bounced perhaps from the general counsel to some administrative person with time ticking all the while, not being able to get the records that you pursue. I think by having a specific person, whether it be at the secretariat level or lower in each agency, I think would make a great deal of sense in streamlining the process. Similarly, the ideas that the legislation speaks to about electronic records make a lot of sense. There are some concerns there that I'll speak to in a minute relating to privacy, but I think the idea that records that are electronic in nature should be more readily accessible than paper records is something that we ought to embrace. Let me speak to the issue of costs of copies. One of the great concerns we have is that we frequently will decide a case, it will be decided that it is a public record. Then having decided it as a public record, the agency will then hit the requester with an enormous amount of fees in order to get the requested documents, frustrating the requester all the more. There is clearly a basis for making a standard fee for replication of public record, whether it be electronic or paper. The area that is the most difficult, and there is regulatory authority on it now, but not that clear, is when you need a person to sort through documents to see where exactly the records are. And you have to have a public employee do that because you have to get the records somehow. That is where the issue is joined. I think the regulation that now speaks to having the lowest compensated employee do that makes a lot of sense. Very often, though, it's very difficult to get to that person. It's difficult to get the decision made, and I could cite specific examples, but it would serve no purpose. We have a large entity that will not make that decision to say this person will sort through the records. I think your effort to have a specific person at each agency would cut through that as well. So I think the two work together to try to get the fees under control. I do think it's important, and I'll speak to the exceptions to the public record law in a moment, but I do think it is important to recognize that oftentimes it has to be some sorting process. You know, I've said before, and I think it continues to be true, that very often the greatest concern in dealing with public records is not access to the records that government creates, it's access to the records that government receives. And very often government receives many records that contain personal information that have to be sorted through. For instance, in my own office case, our corporations division often receives UCC files that contain personal financial information. Our registries of deeds occasionally have had Social Security numbers. If you're looking for those kind of records, and I haven't even addressed the issue of voting records, which indeed have often personal information, we want to make sure that the records that we're giving out are the records that are appropriate to give out, not giving out personal information on citizens. Because it is important also to recognize during this discussion that the only requesters are not simply citizens looking for information or the media looking for information. Oftentimes we have commercial requesters who are looking to build a bigger database for commercial purposes. We certainly don't want to compromise citizens' information. So there is a need to sort through some information. Another problem that I think, and I don't have an answer for you how to sort through this or how to deal with it, but another problem clearly is the issue of requesters who often ask for a very broad array of material when that's not what they really want or need. So for instance, they'll say they want every piece of correspondence for 20 years, when in point of fact, that is a tremendous amount of correspondence. That's not what they really want. My favorite example is, and this is a medical one, but we get a lot of local requests looking for information about school practices. And they perhaps want to know on the school menu how many times donuts were served. But instead of asking how many times donuts were served, they want every menu for the last 10 years. Well, obviously, that's going to require a lot of compilation to put that together. So some means by which we can encourage a more focused request would also help. I think all this speaks, though, to the need to have a more transparent system. The system we now have, I think, is well-intentioned, but has not kept pace with the times. The fact that more and more records are, in fact, electronic, I think is something we have to take into consideration. The fact that very often there is a turf mentality when it comes to records. You could take, for instance, the university system, which has multiple campuses, multiple administrations, but yet when you try to get a specific record out of one particular university, it's very, very difficult because of the diversity of the authority that's there. So I think the idea of having somebody there, the idea of having court costs available if somebody does need to go to court, because very often the media, even if there is a very good faith effort to get information, will in fact not wait or not want to wait and will in fact insist on going to court to do it. So I think the enforcement suggestions that you have made in your legislation I wholeheartedly support, and I think will go a long way towards resolving some of the issues we've seen in terms of enforcement. The more difficult area is the exceptions. There are a number of exceptions. Most of them have been of long standing, some of which are more recent. For instance, we in more recent years have exempted some of the address information of our public safety officials for obvious reasons. There were other changes made after 9/11 regarding the public diagnostic buildings. There are obvious exceptions when you do need to have some degree of protection for the deliberative process. I think that it is important that we carefully consider exceptions. They should not be used as a device for simply avoiding the disclosure of public records. There has been controversy recently relating to the Corey law. The Corey law is interpreted by the commission that enforces the Corey law. The Corey law's interpretation we are bound by. Some have suggested that it has been abused by some police departments when in fact they have withheld information on their own members because of the discretion they have under the Corey law. There may be better statutory solutions to that problem. One possibility might be to give the authority in those cases not to the police department who might be investigating its own member, but rather to the prosecutor in that particular area who may be in a better position to make a fair, deliberative decision about discretion. Obviously, changing the entire Corey law to destroy the rights of Corey citizens to Corey protection, I don't think is something that's likely. While I'm speaking to some of the exceptions, I do think it's important to mention two that are not in the current law, two broad exceptions in the current law that are not covered. One is the legislature itself. I have been asked repeatedly, what do I think about the fact that the legislature has exempted itself from any kind of public records law? Well, I think certainly in the area of employment, in terms of compensation, in terms of contracts made by the legislature, I don't think there's a justification for continuing that, and I would invite your consideration of that. I do recognize, however, that in the area of deliberations, it is important, and I think our Constitution speaks to this, that there has to be some process that allows for a give and take among the legislative members when deliberating the fate of bills. And I'm not sure that a statute that suggests that every single bit of information exchanged between legislators on legislative matters would stand constitutional scrutiny, nor am I certain that that would actually be helpful to the overall process of moving legislation forward and achieving the goals that we seek. Another area that I think invites review is the area of the Lambert case. Let me put that in context for some of your members. The Supreme Judicial Court in the 90s issued an opinion on a case called Lambert. Lambert was the requester. The requester, Lambert, was seeking information relating to the judicial selection process from the then governor. In its answer, the Supreme Judicial Court rather vaguely responded that that information was protected, but it did so in such broad terms that every governor since that time, that was Governor Weld, has taken advantage of the Lambert language to suggest that anything that the governor engages in terms of a deliberative decision is not public record because of Lambert. Now, there's been some variance amongst different governors, but I can honestly tell you, sitting here, that every governor since Lambert has, at one time or another, said that this is not a public record because of Lambert. Once again, like the legislature, it's a little excessive to suggest that every single thing that the governor's office deals with, even if it's of a deliberative nature in some means, by some means, is simply not within the scope of public records. I think most people would agree that the concept of protecting the governor's decision-making when it comes to selecting judges, who he did or she did select or not select, is a reasonable thing to protect. And there may be other deliberative decisions or advice-seeking that a governor does. But certainly the day-to-day correspondence of the governor's office, the day-to-day records that go in and out of the governor's office, they are not and should not be protected by Lambert to the extent that no one can get access to them. And in fact, often circuitous means are necessary to try to get access to these records, perhaps from third agencies. Those are the broad areas. Surely some of the exceptions have had problems. It's important for your committee to know that almost every aspect of the exceptions has been litigated. And when the supervisor makes a decision, the supervisor is required to make their decision based upon the court decisions. And because of the extensive amount of litigation that we've had on public records, almost every aspect of it, privacy, employment issues, has been litigated by the courts. Some cases have suggested that it's clearly under the public record law. Other cases have suggested, for instance, in the area of determining personnel decisions and how one is qualified or whether one is not qualified or whether one was a finalist for a particular position might be protected, that is, not be a public record. So the supervisor isn't making decisions just on a capricious basis. They're making the decision based upon the court decisions. So if you were to look at the exceptions, then I think you have to consider what the court rationale was as these exceptions were crafted. I think the big problem, as I said, has been more in the area of enforcement and more on the ready accessibility of documents. More and more in state government at every level, we are going towards electronic records. We are going towards making sure, just for efficiency purposes, that the information that we use and utilize in making decisions is in electronic format. Having that more readily available makes good sense. There will continue to be sensitive cases. You know, oftentimes they come in the criminal justice system because we do and are anxious to protect the deliberative process of prosecutions and juries when they make decisions. And surely prosecutors and police agencies have the right to protect evidence until they make a public decision regarding prosecution. It can be abused. If a case is truly not a live case, then it should no longer be protected. It can be abused when it comes to the actions of individual law enforcement officers. We've seen examples of that. I certainly would invite your clarification of these areas, but I recognize that there needs to be some degree of transparency there. And if an exception has been abused, then we need to rectify it, and this is the proper place to do it. Lastly, let me reiterate what I said earlier relating to the information government collects. And I say this with the hope of being specific, not as a general catch-all. In fact, I encourage you to do something and to do it now. But I am pointing out to you that oftentimes government does collect a lot of information. And those of us who are the custodians of that information have to be careful on the information we give out on average citizens that come into our possession. We have to make sure that the Social Security numbers, financial information, all the things you would worry about in any commercial transaction are accessible, that we shelter those informations on average citizens. So that is a consideration as we talk about the whole issue of public records. I could spend all day going into the specifics. I'd be happy to answer any of your questions, and obviously we'll be happy to participate in any drafting you do. I'll make people available from my office to give you specific information. I am very anxious to see legislation passed this year. The alternative for me would be some effort at a public referendum. I don't think that's the most precise way to do things. I prefer to see the legislature do it. Be happy to answer it. Madam Chairman.
Thank you, Mr. Secretary.
Before we open up for questions, I also do want to announce that Representative Provost, Representative Campbell, and Representative Flo have joined us as well. Does anyone have any questions?